The Ohio Supreme Court here in Columbus is known as the court of last resort because decisions made here affect the quality of life of every resident of the state. Now, the 7 justices don't make law, they interpret the law on appeal from the state's lower courts. 3 of the 7 seats are up for election this fall. In one of those races, Republican incumbent Justice Robert Cupp is being challenged by Democrat William O'Neill. Justice Cupp served 16 years in the Ohio Senate, 3 of them in the position of President pro tem. Before being elected to the Ohio Supreme Court in 2006, he served as a judge on the Ohio Court of Appeals, 3rd Division.
Many people feel that justice is for sale in Ohio due to the influence of campaign contributions to Supreme Court justices. How can you assure all Ohioans that your decisions will be fair and unbiased in light of the fact that you're receiving campaign contributions from interest groups that expect you to vote their way?
Well, thank you, Brett, for that question, because it is important to reassure the public and the citizens and those who use our court that it is a fair and neutral forum for impartially resolving a dispute. We have an elected system in Ohio, and it's very difficult to be elected if you don't have the sufficient funds to get information to the voters about what one stands for and how one views the role of a judge in our system. We have very strict limits and regulations on campaign contributions in Ohio to avoid the very issue that you raised, that there may be some bias or favor towards campaign contributors. And so we have strict limits and regulations that both on how much can be given, when it can be given, who it can be given to. And so those regulations help protect the litigants before the court about any undue influence from interest groups. There's another factor involved also, and when you're looking at who to support for the Supreme Court, you should also look at one's character and reputation for honesty and integrity and impartiality, because in the final analysis, it is the character of the individual that is being selected as judge that matters the most.
Ohio currently elects its judges, but many people feel they should be appointed by the governor or a nonpartisan committee. What do you feel is better for the community and why?
Well, there are pros and cons on how we select judges, positive and negatives, whether through both the elected and the appointed system. Of course, under the appointed system, the citizens of the state would lose their right to vote for their judges. On the other hand, judges would not have to run in elections, and we could eliminate the role of campaign contributions in financing campaigns. One of the things that's pretty clear, though, is that you're not going to eliminate politics and political influence from either method of a judicial selection. In those in which there is the appointed system, it is still there, only it is not visible to the general public. And while it is a close question, I do think it is important for judges to have to get out into the public as well. It becomes an educational opportunity for the citizens to learn more about the role of the courts and the important role of judges in that system. So on balance, I would say, because the elected system is more open and transparent to the public, that is probably the best way to do it. Also, our Ohio Constitution requires the election of judges, and the voters have twice, by large margins, turned down an effort to go to an appointed system.
As a Supreme Court justice, what would you do to ensure that people in poverty, people that are underrepresented, or people that are otherwise disenfranchised have equal access to our justice system?
It's very important that we provide the ability of individuals to access our court system in order to have disputes resolved according to the law, and so that individuals don't take matters into their own hands. In fact, that is the role of the court, to resolve those disputes, whether it's between individuals and businesses, or between individuals and government. We've done a number of things, I think, that will help promote access to the court. First, for small claims, it's a more informal procedure that individuals can go into court and do not need a lawyer, and the rules of procedure are more relaxed. We have also developed some individual guides that individuals who are representing themselves can use to better understand the legal system. Unfortunately, I think with the economic conditions, it has sort of made it more difficult to provide legal assistance for people who can't afford it through legal aid or other means. And one of the things we're trying to do is to encourage attorneys to provide more free service to individuals who need it. And we're now looking at changing our continuing legal education requirements to give some encouragement to individuals who provide extra service to individuals who can't otherwise afford it. It is an important question. It's not one that the court itself can entirely address. It takes both the state and the local level and the legislature and the courts working together to solve this problem, to provide adequate access to our legal system for all individuals.
When it comes to sentencing, which do you prefer, judicial discretion or minimum mandatory sentencing?
Well, that's a very interesting question, and it really involves one that's more in both the legislative and the judicial branches, because it's the legislature that determines what the maximum and minimum sentences will be, and then it's the judge that applies the actual sentence based upon the facts and circumstances in an individual case. I think the preferred method, of course, would be to give the judge discretion, because every case is different. It has its own little nuances and factors about the individual and the facts of the crime that the judge needs to weigh in deciding what is going to both be the punishment for the individual who is convicted of a crime, and perhaps the best way to rehabilitate them as well and bring them back in so that when they are able and productive and law-abiding citizen in the community. Unfortunately, it is kind of a balance, and not all judges exercise great discretion, and that's why sometimes the legislature feels they need to step in and set a minimum floor. But I think in the long run, it's better to give the judges the discretion they need to tailor the sentence to the individual involved that will make it most effective.
There's been a lot of discussion lately about judges legislating from the bench, effectively rewriting the laws that the legislature has previously written. How do you feel about that issue?
Well, Tony, I think I bring a little extra perspective to this, having served in the legislature for 16 years before now serving in the court and the judicial system for almost 10 years. And before that, I was a county commissioner, so I served in the executive branch. One of the important things is the difference between the two branches, the judicial and the legislative. My own view is that a judge's role in our constitutional system is an important role, but it's a limited role. And that role is to apply the law as it is, as it's written, according to the precedents, according to the plain and ordinary meaning of the statutes, and not to rewrite the law or to try to remake the Constitution. I don't believe that is the role of judges to try to reshape the law, to put their own personal view of what the law ought to be into their decisions. You have a very public process in the legislature, the legislative branch that makes the law. The court system is a much more closed process, and so there isn't that opportunity for public input or dialogue. And therefore, that makes the legislative branch a better place in which to make the law and public policy.
We still have a foreclosure crisis in Ohio. It's been 5 years since the Supreme Court took the initiative to encourage attorneys across the state to represent homeowners in foreclosure cases, and also to set up mediation programs in the counties. What will you do to review how that process has worked and to strengthen it going forward?
Well, we've heard some negatives and positives about the program. The positive is that many lawyers have volunteered to be of assistance. The negative is that in many cases the homeowners that are underwater have not taken advantage of it, or it really hasn't worked. I think we do need to evaluate it, and it may need some changes in the law to improve the system that we have. And that, of course, requires the legislature and the governor and the courts and the Bar Association and Legal Aid Association all to work together to come up with something that will really be of assistance in these situations.
During the campaign, voters will be asking you a lot of questions about specific issues. How will you answer these questions so that voters will have the information they need when they go to vote without violating the Judicial Ethics Code?
Well, Victoria, that's a very difficult thing for judges to do, and so one must approach it very carefully because we don't want judges to take positions on disputed political or legal or social issues that might affect their judgment if a case eventually comes before the judge involving those matters. So what judges can talk about is their background and experience, as well as their view of what the role of a judge in our constitutional system is. And those items, I think, will provide information to the voters as to what a judge is like. There are other ways of looking at it as well. For example, the Ohio State Bar Association rates the candidates for the Supreme Court, and I'm pleased that I got their highly recommended rating. But if you go to those organizations, you'll be able to get some additional information on the judges, as well as by watching well-developed and well-produced shows on television that involve the judicial candidates.
If you're elected as justice, will you make your decisions based on your political affiliation or what you feel is best for the people of Ohio?
Well, Connor, first let me say that I was a political science major as well. Having served in all three branches of government in the elected position, it is clear that there are significant differences between the role of each institution. As judges, we don't represent a political party or have a partisan political viewpoint. Our oath is to administer the law without bias, without prejudice, fairly and equally to all individuals. I try very hard to make decisions that are simply based on the law and let the chips fall where they may. I do not take into account partisan considerations, and I don't believe that other justices on the court or judges in Ohio make decisions based on partisan political considerations or affiliations.
There seems to be a philosophical difference of viewpoint on the court about the punishment of juvenile offenders. In your opinion, should juveniles be treated differently from adults in all cases? Do you believe there are some punishments that are just too harsh for juvenile offenders?
Well, juveniles certainly are different from adult offenders, and I think the U.S. Supreme Court has recognized that in several of its decisions. Here in the Ohio Supreme Court, there's been questions involving what is the appropriate punishment for juveniles, as well as sex offender registration requirements. Every case is, in many cases, have to be weighed individually. And while juveniles do deserve some differences in their punishment, there's also still a role to be able to protect society from those who are going to continue to harm law-abiding citizens in our community. So again, it's kind of a balancing situation where the legislature and the courts applying the law and the Constitution try to arrive at a circumstance and have laws which will truly try to help rehabilitate those juveniles who can be rehabilitated and become productive law-abiding citizens of our community. People do sometimes disagree on what the limits of the Constitution and the limits of the law are on that, but that is a healthy aspect of our judicial system in which we continually reevaluate those concerns.
The office of the Ohio Supreme Court is a highly influential position. I'd like to know three things about justices who are running for the Supreme Court. Number one, what has been your greatest accomplishment in administering justice? Number two, what has been your opponent's greatest accomplishment in administering justice? And number three, what has been the Ohio Supreme Court's greatest accomplishment in administering justice?
Well, the role of a judge is to apply the law in a neutral and fair manner to all of the litigants that come before the court in order to protect individual rights and property rights and peacefully resolve disputes. And I think the best way to do that is to have a legal system that is stable, consistent, and fair, one in which the law does not change on individual cases, but the same rules apply to all individuals. And that is what I have tried to do during my service on the Supreme Court to create that stable and consistent legal environment in which individuals will be able to know what the law is and how it applies to them, and able to order their conduct, and so that they can conform to it and they can protect their rights against the conduct of other individuals and government itself. So I have worked hard to help accomplish that, and I think we have succeeded during these 6 years. There's always more to do. And I would say that that is probably also the single greatest accomplishment of this Ohio Supreme Court, as long as I've served on it, is to create that stable, predictable legal environment, which benefits the citizens of Ohio. And I'm just simply not able to talk to what my opponents' legal accomplishments, I'm not able to talk to what my opponent's legal accomplishments might have been. It's been a great honor for me to have served as a Justice of the Ohio Supreme Court for the last 6 years. My goal in serving on the court and running for re-election is to help maintain a legal system for Ohio that is stable, consistent, and fair, one that applies the rule of law, and one in which the judges honor the separation of powers between the branches of government. That is, to decide cases based upon the rule of law, the plain meaning of the statutes and the Constitution, and not to try to rewrite either from the bench. It is this which gives us that stable, predictable system which best preserves our system of ordered liberty. As someone who has been elected to serve in all three branches of government, I bring a unique experience to the work of the court, having served as a city prosecutor, a county commissioner, a state legislature, and a judge on the Court of Appeals, and now upholding the law and the Constitution as a member of the court. I encourage your support. Thank you.
If you have questions about where, when, or how to vote, contact your Board of Elections if you live in Ohio, or your county clerk's office in Kentucky or Indiana. Tom McKee, 9 News at the Ohio Supreme Court in Columbus.